Yes, that is the proper name, the full name. If you'd like to follow on Twitter or tweet or anything during the course or during the Expo, the Twitter name for the Creative Collaborative Collective is up there. It's at Creative Col Col. And then the Twitter name for the Expo is at Photo Film Expo in capital letters. So if you'd like to tweet while we're going, that'd be great. So, I'm going to be speaking on intellectual property, specifically focusing on copyright and for photographers. A little bit of background about myself. I am a working commercial photographer. I shoot advertising, editorial, both locally and internationally. I'm also a part-time lecturer in professional practice. I lecture at the Stellenbosch Academy of Design and Photography and also at the Cape Town School of Photography. I've also lectured at the Market Photo Workshop and at City Varsity as well. And I'm also the founder of the Creative Collaborative Collective, which I'll tell you a little bit about, I'll tell you more about a little bit later. Okay. Right, so why IP? Why is there all this fuss about copyrights? Many of you will have heard from professional photographers about how they moan about South African copyright law and about how unjust the South African copyright law is and about how we should be burning down Parliament because they won't change our copyright law and stuff like that. And what I actually want to tell you is that the copyright law is actually not that bad. You just have to know how to use it. So I'm going to try and share a little bit of that with you as to how do we actually make the copyright work for ourselves, because the law does empower us to own our own copyright to our images. In fact, if you go out and shoot yourself, if nobody commissions you, you by default own the copyright to your images. So from the onset, you own your own copyright. So I'll elaborate on that a little bit more. That is unfortunately what happens to most photographers' intellectual property, most commissioned photographers, because they don't know how to protect their copyright. So, how do we do that? If you want to dispute the value of intellectual property with me, I'm very happy to do that. But the best way that I can summarize is that if you don't believe or if you doubt the value of intellectual property, then please ask this gentleman up here by the name of Bill Gates. He's one of the wealthiest men in the world today because of intellectual property. Bill Gates does not sell software. He sells intellectual property. When you buy the software that Microsoft produces, yes, you buy a disk with the software on or you download it, but what you're actually buying from Microsoft is a license for use. And if you go and take that software and you load it on multiple machines, you have to buy multiple licenses for use. And if you don't, then the Microsoft police come and find you and they do all sorts of unpleasant things to you. And that's the best analogy I can give you. Photographers are in exactly the same boat. We don't sell photographs. We don't sell photographs. We sell license for use of our photographs. And it's very important that you understand that distinction from the beginning. Right, so what? Where do we go from here? The United Nations takes copyright and intellectual property incredibly seriously. Our South African law is a little bit backwards. The reason why our law is a bit backwards is because we inherited it from the British. And the British changed their copyright law in the 80s. New Zealand, Canada, Australia, all the previous British Commonwealth countries all had the same law that we have, and they've all either changed it or they're in the process of changing it. So New Zealand has changed it, Canada has changed it, Australia is currently in the process of changing it. Unfortunately in South Africa we're a little bit behind, so we haven't even basically looked at it yet. What many of you might not know is that our copyright law did actually change in the early 80s, and it changed this to the place where photographers own their copyright by default. But unfortunately it was changed back in the same year that it was changed. And nobody's quite sure why or how it was changed back, but it was. So there was obviously some kind of external pressures that it came to play. Within the United Nations, in their Declaration of Human Rights, you might have heard of that document. It's one of the founding principles behind the United Nations, is the Declaration of Human Rights. In Article Section 27 of the Declaration of Human Rights, it says there that everyone has the right to freely participate in the cultural life of the community and enjoy the arts. And in point 2, it very specifically says that everyone has the right to the protection of the moral and material interest resulting from any scientific, literary, or artistic production of which he is the author. Now, as a photographer, we always feel a bit strange when we get told that you're an author, because we always think of an author as a writer. But in copyright terms, if you create something, if you create a story, if you create an image, if you create a painting or a sculpture, then the law refers to you as the author of that work. Okay, so from now on, every time you hear the word author, please just see yourself in that light as well. Okay, So if the United Nations decided that as an artist, as a photographer, as an author of your work, it is so important for you to own that work so that you can protect the material interest in it. If they decided that it was so important, they actually enshrined that in the Declaration of Human Rights, then it gives you an idea of how the international community views this, how seriously the international community views this. Okay. Okay, sorry, it was a bit too quick there. So basically, what is intellectual property? This is a very brief overview. It's a legal term describing the fact that people have rights to their creativity and innovation. And one thing that people often get wrong is that they think that you can protect an idea, you can copyright an idea, you can't. It's not legally possible to protect an idea. You can only protect the idea in a manifested form, in a physical form. So once the idea has been made into something tangible, that thing can then be protected. Okay. And it protects things such as designs, inventions, film, music, painting, photography, sculpture, and writing. Right, the main reason why we need to protect our IP rights is because we want to be able to benefit materially from it, we want to be able to benefit financially from it. And in order to do that, you have to own the copyright, because if you own the copyright, you can then sell the license for use of that image or painting or whatever it is in this case. Okay. And the other reason why you need to own it is that if somebody breaches your copyright, if somebody abuses your image, uses it without your consent, you then need to be able to reach a financial settlement for the use of that image. And that's why you have to own the copyright for that as well. Sorry, this is jumping through very fast. Okay. So what does copyright itself do? Copyright falls under the umbrella of intellectual property. Copyright itself protects the right of the creator to reproduce the work. And it's not just the creator, because copyright can be assigned, which means that you can sign it over to somebody else. So copyright law protects the rights of the reproduction of that work. Some uses are allowed, so limited private or personal use is allowed. So, for instance, if somebody takes an image off your website, even if you have a copyright notice on it, and they use it for their own personal use, they are allowed that without actually having to pay you for that use. It's only when there's a financial transaction there's actually when there's a material benefit that's going to arise out of it, that people then need to pay you for that. Okay. And one of the important things about South African copyright, it also applies to countries like the UK and America, is that copyright can be assigned. In other words, you can sign it over to somebody else. In countries like France and Germany, you cannot assign copyright. It's impossible to legally it's possible to divorce the copyright from the author of the work. But in many countries of the world, you can. If I'm talking too fast, please just show me a hand, because I do tend to talk very fast. So in South Africa, we have this wonderful piece of legislation, which is called the Copyright Act 98 of 1978 as amended. As I mentioned, it was amended in 1980, and then it was thrown back to the 1978 version. And that covers literally musical, artistic works, films, sound recordings, broadcasts, etc. And an artistic work includes paintings, sculptures, drawings, engravings, and photographs. Okay, one of the very important things about it is that the artistic quality thereof is irrelevant. How good or bad the photograph is, how good or bad the painting is completely and utterly irrelevant. It's still protected by copyright. Okay. The reason for that is because it's so subjective. In your opinion, what is a good photograph is not necessarily a good photograph in somebody else's opinion. Okay. Another thing a lot of people don't know is that copyright has a lifespan. And in South Africa, it's 50 years. So the lifespan of copyright in South Africa is measured in two ways. The first way is from the date of first publication. So if you are commissioned by a magazine to do a story, the date that that magazine is distributed and it's published, then from that point onwards it's protected for 50 years by copyright. Once that 50-year period is over, it's then open to fair use. Okay. The second thing is that if the image is never published, then it's 50 years from the time of creation. So what happens quite a lot is you have a lot of very good photographers, it doesn't matter whether they're amateurs or professionals, you have a lot of very good photographers who build up archives during their lives. And very often, a lot of the photographs that are in the archives never actually get used, they never actually get published. If, because copyright is property, you can inherit it. If, for instance, you inherit the estate of somebody who has a collection like that, those photographs will be copyrightable from 50 years from the time that they were created, if they've never been published. Okay. The difficulty with that is how do you prove when a photograph was created? Digitally these days it's very easy because we have the metadata in the file and the date stamp is in the file. But if you were shooting on film, how do you prove when that photograph was created? And there we normally have to go back to processing invoices or any other piece of evidence that you can find to say that it was created in that year. A very good thing as a photographer, if you are shooting film, is when you archive your film, is to actually write the date on the sleeve that you're archiving it in. Okay. Just an interesting thing to note there is that the lifespan of copyright has nothing to do with the lifespan of the author. So it's 50 years from time of publication or 50 years from time of creation, irrespective of whether the author is alive or dead. Okay. During the 50-year period, if you own the copyright, you can regulate the use of copyright, and that's where we want to get to. We want to get to the stage where you own the copyright so that you can regulate the use for it. If you don't want to sell the image to somebody, if you want to give it away, you can, it's yours. Okay? If you want to sell it, you can then sell the license for use thereof. Okay. After the 50-year period, it will cease to exist, and then anybody can use the images. Right, the United Nations in 1948, when they drafted the Declaration of Human Rights, enshrined the ownership of copyright with the author. But before that, in I don't remember the exact date now, but it was 18 something, we had the Berne Convention. And the Berne Convention was established, there we go, 1886. The Berne Convention was established for the protection of literary and artistic works. So you can see how long this has been something of importance for them. And we're talking about 1886. We're not talking about something we thought about in 2010 or 2011. We're talking about 1886. Okay. The importance of the Berne Convention is that we have something called the TRIPS Agreement, which is the Trade Relations and Intellectual Property Agreement. And South Africa is a signatory to the TRIPS Agreement. So even though our copyright law says one thing, our copyright law only applies within the borders of South Africa. The very second that an image leaves the borders of South Africa, when it's used outside of the borders of South Africa, the TRIPS Agreement then kicks in. And the TRIPS Agreement refers to the Berne Convention. Okay. And the important thing to know about that is that we have something called the principle of national treatment. And what that means, that the country in which the image is used, the law of that country applies. So for instance, if the image gets used in Germany, and German law says that copyright cannot be assigned, it cannot be divorced from the author, and by default, the author is therefore the owner of the copyright. And the South African Advertising Agency, for example, wants to use your image in Germany, they have to buy the rights to do it, or they have to request the rights to do it from you. They cannot just do it, even if they own the copyright in South Africa. Okay. Again, if it went to America, American law would apply. If it went to Kenya, Kenyan law would apply. If it went to Swaziland, Swaziland law would apply. That's the way it works. Okay. Right. In the copyright law, I'm going to go through this quite quickly, but basically we're looking at Section 21. And in Section 21(1)(a), it speaks about the ownership of copyright, and here it says that by default, the copyright shall vest in the author of the work. So you as a photographer, if you are not commissioned and if you're not employed by somebody as a photographer, you by default, we recognize that the author of that work, and you will own the copyright in your work automatically. So it's automatic protection. Okay. And with that automatic protection, you can then sell license for use of your work. So this is default law. You don't have to enforce it in any way. You don't have to register the copyright with anything. It's not like a trademark which has to be registered. It is default protection. Okay. Alright, Section B basically tells us that if you're employed, Section B basically tells us the exception to that is if you're working for a publication. So even if you're a freelance photographer, whatever the nature of your employment is with the publication will then by default own the copyright to your work. Okay, this is why it's so important. If you submit your work to a magazine, there's many magazines that rely quite heavily on reader submissions. If you submit your work to a magazine, it's very important that you notify the magazine that you retain the copyright and that you are granting them once-off license for use. Okay, if you don't do that, they will assume that they own the copyright to your work. So it's very important to establish that. Right. Section C is the part that all the professional photographers get so upset about. Because Section C says that if you are commissioned to produce a photograph, then the commissioning agent will own the copyright to that photograph by default. Okay. The problem with this, the worst part about this particular part of the law, is that it says there very specifically that if they pay or agree to pay. So in other words, they commission you, you do the shoot, they have not paid you yet. They own the copyright. Even if they take 2 years to pay you, they still own the copyright. And that for me is the worst part about this law. It also says in money or money's worth, and that you need to be very, very careful of, because anything which is tangible is deemed to have money's worth. So if I say to you, I'd like you to shoot my portrait and I'll give you a Coke in return for shooting my portrait, then I will by default own the copyright because I've given you something that has financial value, even though it's only a Coke and worth £7. Okay. And this is the part that you need to learn. So, Section D just speaks about that if it doesn't fall into sections B and C, then we're going to refer to something else to come back to that. Section E is the part that empowers you to agree otherwise. And this is why I say what a lot of professional photographers don't know is that the law actually does empower you to own your own work, even if you are commissioned. Because Section E very specifically says that sections B, C, and D shall in any particular case have effect subject to any agreement excluding the operation thereof, and subject to provisions of Section 20. And I'll speak about Section 20 now. So if you are commissioned to produce a photograph, to create a photograph, you can, in your documentation, specifically state there that you shall be the owner of the copyright from the time the image is created, empowered by Section 21(1)(e) to do that. And if the client does not object to that, then you will, by default, own the copyright to your work. Okay. Right, Section 20 is very interesting because Section 20 speaks about our moral rights. And Section 20 very clearly says that if you are the author of you have a moral right to claim the authorship of your work. Okay. What it also says, it says you have the right to object to the distortion, mutilation, or other modification of your work. Now, what this means, and advertising is a very classic example of this. An advertising agency commissions you to go and create an image, and you create a beautiful image. They then take it and they digitally manipulate it, they alter it, they drop stuff into it, they take stuff out of it, and at the end they wreck your image. Okay? You have the moral right to object to that. You have the moral right to stop them from using your image. Because it is your image, it's your reputation on the line. Okay. Right. Any infringement of Section 21 says that you will be deemed, Section 20 and the infringement of Section 20, so that you will by default be deemed to be the owner of the copyright in question. Which is quite nice, because it means that even if you're commissioned, and even if you don't do your paperwork properly, and they own the copyright, but you contest it based on your moral rights, then you will by default be deemed to own the copyright. Okay. Please remember, we don't sell photographs, we sell intellectual property. And this is the reason why. Again, if you don't believe me of the value of intellectual property, please speak to Bill Gates. He seriously is one of the wealthiest people in the world today because of selling license for use. As photographers, we're protected by the same laws. We can also sell license for use. We can also benefit financially from our works, especially when your works go out internationally. Just a bit of a breather. I was born in Cape Town. I went to school in Johannesburg, and now I'm back in Cape Town. I believe that you guys call it Gauteng, is that right? Okay. Cape Town, our province is called Mountain. We have this big object in front of us, and our perception of the rest of South Africa is that we're Cape Town, and then the rest of South Africa is Johannesburg. Johannesburg's so big, and like there's so much stuff that happens there. Anyway. Right. Moving on. Once you own the copyright to your image, you then need to sell license for use. How do you sell license for use? This comes back to a principle that we call base usage rates. So when you supply a cost estimate, and please always use a cost estimate, not a quotation. The reason being that a quotation is a legally binding document. A cost estimate is exactly what it says. It's an estimate of costs. And the problem with photography is that there's so many variables that happen on shoots, and they happen very quickly, that sometimes you have things that have implications, cost implications that are out of your control. The best example I can give you of that is the weather. You can have a shoot which relies on good weather, and in Cape Town, this is the biggest thing in now, because we have 4 seasons in one day. So you can plan a shoot around having good weather, you head out for location, and suddenly the southeast is blowing gale force, and on top of that, suddenly it turns, and then the northwester comes in and it rains, and now instead of it being a half day shoot, it's a full day shoot, and you roll into overtime, etc., etc. Those kind of things are beyond your control. Okay, so that's why we always refer to it as a cost estimate, not a quotation. So base usage rates. What is a base usage rate? We often refer to our rates as a day rate. When clients ask us to supply rates, we say my day rate is, or my hourly rate is, or my half day rate is. What we should be saying is my base usage rate is. What is the base usage rate? It's the rate that we charge for the primary use of the images that we create, and very specifically for commissioned images, and it is very specifically limited to that use. So in other words, if a magazine commissions you to shoot for the magazine, they're commissioning you for editorial use. Editorial use does not extend to advertising. So it's happened to me a number of times where, for instance, if I'm shooting for magazines like Clicks Club magazine, I shoot for the magazine, and then Clicks comes afterwards and they say, we love the picture, can we use it for in-store point-of-sale advertising posters or something? And they can with the greatest of pleasure, but they have to buy the rights to do that from me. Okay, because of the base usage rate. So the next thing is categories of base usage rates. In South Africa, we use 4 main categories. The one category is advertising. The second category is what we call commercial use, which is basically aerial, catalog, corporate, or social. So weddings would fall into that, PR functions would fall into that, corporate events, things like shooting for annual reports, shooting for graphic design agencies, anything which is basically non-advertising would fall into that. We have advertorial use, which is a wonderful thing that magazines invented to try and encourage people to advertise in their magazines, but just pay photographers less for doing it. The difference between an advertorial and an advert is that an advert is put together by an advertising agency, and an advertorial is put together by the magazine's publishing team. And a photographer would get paid like an average base usage rate for advertising would be 8,000 Rand, and an average base usage rate for advertorial would be 3,800 Rand. So we pay the magazines 4,200 Rand a day for the privilege of shooting for them at their advertorial rates. It sounds a bit cynical, but it's the way it is. And then editorial is strictly editorial, working for magazines, newspapers, news websites, etc. Okay, so those are the 4 main categories that we have of base usage rates. Some people don't call it commercial, some people call it corporate/design. It's the same thing. Right, there are 3 factors that govern license for use. So when you're selling license for use, the 3 factors are time, territory, and media. Time is normally based on years, although internationally they will if you're shooting advertising internationally, they will quite often ask for 6 months use. But generally speaking, time is governed by years. Territory is the country, it's the borders of the country. So even though Lesotho is inside South Africa, it's a separate territory, it's a separate country. Lesotho law will apply versus South African law will apply. And then the third is media. So what media will it go out in? Media, a good example is if you're going to shoot for a magazine, the base usage would be 1 use in 1 edition of the magazine. That's it. 1 use in 1 edition of the magazine. If it's advertising, it would be 1 year in 1 country in 2 media, or 2 years in 1 country in 1 media. So the territories are not interchangeable, but the time and the media are interchangeable. Okay, so standard advertising use is 1 year, 1 country, 2 media, or 2 years, 1 country, 1 media. Okay. And again, it's unless otherwise agreed. Sorry, that's a double slide, I'm not sure why. Okay, the next question comes is, if you shoot for an advertising agency and they say to you, we now want to use the image in the UK, how do you calculate what you're going to charge them? That's the next big question. So it's quite simple. There's an association called the Association of Photographers. Their website address is theaop.org. It's a British-based association, although they are an international association, but they're based in London. And they've done an incredible amount of work into license for use, calculating usage, etc. They have a downloadable PDF on their website, which gives you the territories. And there you can see as an example, you commissioned in South Africa, but they want to use it in the UK. And so then you charge 100% usage in your base usage rate. So if you charged 8,000 Rand in South Africa, you would charge them 8,000 Rand again to use it in the UK. It's 100% of your base usage rate. One thing I must make clear, it's not 100% of the job value, because every job is production costs. And your production costs might run up to 100,000 Rand. So it's 100% of your fee, of your base usage rate, not of the total job value. Okay. You can see there that worldwide usage will be 500%. The ultimate buyout that you get is something that we call worldwide in perpetuity. So what it means is that they can use the pictures anywhere in the world for all time. And the best thing about that is the catching on the money in photography. If you shoot an advertising campaign that gets worldwide in perpetuity buyouts, you're looking at a 3,000% buyout of your base usage. And that is where the money is in photography. I'll give it to you. It's v-aop.org. They also have a brilliant, on their website, they have a brilliant usage calculator. And the way the usage calculator works is that you enter your base usage rate, and then you enter the number of media and the number of territories and the time it's going to be used for, and then the usage calculator tells you how much you should charge. Yes?
Sorry, just to clarify, by base usage rate, you mean your hourly, half day, or day rate?
Yeah.
Excluding things like editing fees?
Yes. Yeah, it's your photographic fee.
Okay, so your professional time, basically.
Yeah. But again, we don't sell time, we're selling intellectual property. Yeah.
Just different ways.
Yeah. But basically the way it works is that our base usage rate is it's the intellectual property value of what we produce, but it has time constraints. So an advertising day would be based on 10 hours, an editorial day would be based on 8 hours, a commercial day would be based on 9 hours, and a half day would be half of that. So half day advertising is 5 hours, half day editorial is 4 hours. Okay. Right. Please remember that in South Africa, Section 21(1)(c) says that photographers will own their own copyrights unless they are commissioned. If you are commissioned, the commissioning agent will own your copyright by default. Okay? So what do we do about that? How do we do that? How do we enforce Section 21(1)(e)? And quite simply, it comes down to good business paperwork. Now, I know that with the photographers, generally speaking, we're creative people, we're not administrative people. Generally speaking, our paperwork is pretty shoddy. So the easiest way to do this is you have a template. You can put together a cost estimate template. I'll show you an example of that now. So this is just the top paragraph of a cost estimate template. And at the bottom of the template, okay, first of all, you can see here it says photographic charge base usage rate, in brackets BUR, commercial online catalog. So there it's specifying that it's a commercial base usage rate, and it's specifying that it's for online catalog use. So in our cost estimate, we've defined the use from the onset. Okay? There are base usage rate fees. It's 5,900 Rand for 1 day, and that's restricted by 9 hours because it's a commercial fee. Okay? From there, in our terms and conditions, we then have the point number 1. It's hereby agreed that the photographer is recognized and constituted as the author of the commissioned works produced and shall be the owner of the copyright therein throughout the world. What that is that one line enforces Section 21(1)(e). So we're using Section 21(1)(e) of the Copyright Act. We're enforcing it in writing in our cost estimate, which very specifically says that you will be the owner of the copyright from the time that the images are created. Okay? The next important part about this is it says that, remember, we're selling license for use. The biggest reason why clients want to own copyright is because they want to prevent other people from using the images for things that they don't want it to be used for. So as an example, you do an advertising shoot, and you create a beautiful image of a bottle of Coca-Cola. What Coca-Cola does not want is they don't want you to go and sell that photograph to their opposition to do something nasty with. That's why they want to own the copyright to it. So how do you put your clients' minds at ease? The best way to do it is you give them what's called exclusive license for use. Now what exclusive license for use is it says that they will be the only people that are allowed to use that image during the period of the license period. So if the license is for 1 year, then for 1 year they'll be the only people that will be allowed to use it. That's why sometimes big companies they'll do the worldwide buyout in perpetuity because they want to own that image for all time, anywhere in the world, exclusive license for use that nobody else can use it. Okay. Remember section 21(1)(c) said that the client owns the copyright if they pay or agree to pay, so they can use the image without paying. Here's where we change that. You can see here we say the exclusive license is conditional on receipt of payment in full and final payment, within the payment period agreed. So if you give the client 30 days to make payment, if they pay within 30 days, they have the exclusive license for use. If they don't, it falls away until you receive full and final payment. Okay, it's very important to include terms like this, because if the clients use your images before they've paid, you then hand them over for debt collection. Okay. The last few points are just reinforcing, defining what a client is, and the last point says that the photographer retains the right to use the photographs for self-promotional purposes. Now what that means is that it doesn't matter who you're shooting for, it doesn't matter what the license conditions are, you are always entitled to use that photograph to promote yourself as a photographer. In your portfolio, on your website, if somebody does an article about you as a photographer, anything which is going to promote you as a photographer, you are entitled to use those photographs. Okay, regardless of who owns the license for use for it. All of these conditions around license for use can be changed by mutual agreement. So everything around that is unless otherwise agreed. Okay. Right, one of the biggest questions that I get is, somebody's abused my copyright, what do I do about it? The problem is that in South Africa, litigation is incredibly expensive and it takes a long time. If you try and sue somebody for copyright, you're looking at probably a minimum of a 2-year suit. If it actually goes to court, and if it does go to court, normally the expenses are more than the value of the amount that you're trying to claim. As an example, we recently had a case of a Belgian photographer who's living in Somerset West. Somebody stole one of his images off his website. They used it, they appointed an independent auditor to calculate the value of the use. They calculated that the value was 60,000 Rand for the total use. The costs of the litigation were going to be 80,000 Rand. So he walked away from it because it wasn't worth suing for that. There is, however, a much easier way to resolve this. If you discover that somebody has breached your copyright, all you do is you calculate the value of the use and you send them an invoice for it. With that invoice, you have a covering letter saying, it's come to my attention that you've abused my copyright. This is the value of the use of what you've used. Here's the invoice for it. You have 30 days, 7 days, or whatever payment period you want to give them to pay it. And if you don't, the account will be handed over for debt collection. The reason why that is so much better to do is because debt collection is much cheaper than trying to sue somebody for breach of copyright. Much cheaper. And if you can then present your case, if it does go to court, and you're presenting your case to a magistrate, because normally debt collection is resolved in magistrates' courts, you can then present your case to the magistrate saying, I am the owner of the copyright, this person used it without my consent, this is the value of the breach I've invoiced for them, they owe me the money. The magistrate is quite likely to agree with you and to enforce that. Okay. That is a much shorter process in periods of time, much shorter process, and a much more cost-efficient way of doing things. Again, why do we want to own our copyright? Why are we fighting so hard for our IP? Why do we need to actually do good paperwork? When I say good paperwork, you can draw up one template. Your cost estimate, it's one template. You can do it in an Excel spreadsheet. You can do it in numbers if you're on Mac, whatever it is. You have your terms and conditions there, and all you do is you change the amounts that you have to, and you change the client's address, whatever it is. So you only have to do it once, and then just keep on using it. Incidentally, on this point, it has to be on your estimate. It cannot be on your invoice. If you put your terms and conditions on an invoice, that's post-fact. In terms of South African contract law, it won't hold up. If it's on your cost estimate, it forms part of the contract documentation that leads up to the commencement of that work. Okay. Right, what is the Creative Collaborative Collective? The Creative Collaborative Collective was started in November. I started it, and the reason why I started it is because photographers are a fascinating bunch of people. Generally speaking, photographers are a bunch of mavericks. We don't seem to like to do things by the rules. We don't seem to like to stand together. There seems to be a lot of infighting, and just about every photographic association that's ever tried to get off the ground in South Africa has fallen to pieces because of infighting, because of politics, because of all of those things. So I looked at it and I thought, how do we resolve this? How do we resolve the infighting? How do we get photographers to stand together? What is the solution to all of this? And the glaring solution to me was sharing information, because information is power. If we can inform photographers, if we can educate photographers of what their rights are, if we can teach photographers about good professional practice, about what they should do to protect their rights, then we can unify the community. So the Creative Collaborative Collective is exactly what it says. It's a collective, a very loose collective. There's no body, there's no committee, there's no anything like that. We don't have to have anything like that, okay? It's simply a collective of photographers where we collaborate together and we share information with each other. Okay, we don't have AGMs, we don't have any of that, we have none of that. It's a very loose association where we share information with each other, that's it. The intention is that as it grows, we will then start doing things like hosting exhibitions, producing books of work, etc., etc., etc. Where you can find us on Facebook, the icons have jumped there. The top is our website address. Yes, it is that long. It's creativecollaborativecollective.org. The nice thing about it is that once you've typed it in once, it's in the memory, you don't have to. And it's cross-linked in many, many places in the internet. It's cross-linked, so you can just click on the link. That was just I've got a bit of a dark sense of humor, so I thought I'm going to make people type this name in. On Facebook, we have an open Facebook page which is open to the public, and that is Creative Collaborative Collective. So it's facebook.com/Creative Collaborative Collective. You can go onto the page, you can like it. We post articles of interest onto the page. We post anything and everything to do with photography. Anything and everything to do with photography. We post onto that page. That page is open to the public. Then we have a closed Facebook group, which is by invitation only. And the closed Facebook group is also called the Creative Collaborative Collective. What you can do is you can look on Facebook groups. You can send us a request to join the group. There's only one criteria to join the group, is you must be a photographer. And I don't care whether you're a professional photographer or an amateur photographer, I really don't care. You must be a photographer, that's all. I don't care whether you use a Hasselblad H5 or whether you shoot on your iPhone. You must be a photographer. That's the only criteria to join. Okay. Once you join, the information that we share on the Facebook group is slightly more sensitive. So it's not stuff that we're just throwing out in the open for everybody to consume. It's stuff which is slightly more sensitive, which we want to just keep within the community. Okay. Lastly, on Twitter, we are twitter.com/creativecolcol. Twitter wouldn't allow me to put Creative Collaborative Collective. Yes. Sorry, I can't hear. Yes. Yes. I will upload it to the website, Creative Collaborative Collective, and I'll post it to the group, the closed group. I won't put it on the open group, but I'll put it in the closed group and I'll put it on the website. And you're welcome to download it. You're welcome to use it. Just to clarify one thing, the terms and conditions on the cost estimate that I'll make available to you, I didn't just do those on my own. I didn't just suck it out of my thumb. I consulted with one of the top intellectual property attorneys in South Africa, a man by the name of Dr. Owen Dean. He's from a firm called Spur & Fisher in Cape Town. And Dr. Dean is now the chair of intellectual property for Stellenbosch University. So those terms and conditions were drafted with him. And he is satisfied that they fulfill all the legal requirements that we need to fulfill in order to achieve the objective that we want. And he's satisfied that they're legally binding. He's satisfied that using that cost estimate only, your client does not have to sign it. This is a very important point to note. Your client does not have to sign the cost estimate. Simply by submitting the cost estimate and your client starting the job, your client giving you the go-ahead to start the job, that becomes legally binding in terms of the contractual process.
So that information
it will be on the website. Yeah. If you could just give me time to get back to Cape Town, so I'll post it on the website. If you can give me until Wednesday next week, I'll post it on the website by Wednesday next week. Okay, yes. Sorry, yes, in the front here. Okay, that's a very difficult question to answer. The question was on moral rights. Essentially, how much editing is okay and how much is not. That's a very, very difficult question to answer because it's up to the photographer's discretion. Yeah. Okay, two things there. First of all, if you are working for somebody as a photographer, okay, if you took the photographs in your own time, you own the copyright. If they've used the images, did they have your consent? but they cropped your name off it. Yeah. Okay, the problem with that is that cropping is acceptable. In terms of changing a photograph, cropping is acceptable. Again, the question comes up, how much cropping is acceptable? Normally they work in a figure of about 20%. More than 20%, you can argue that it's detrimental to the aesthetic value of the image. But ultimately, you can enforce Section 20, you can enforce it, you can say it's breach of immoral rights, that you have the right to object to it. You can ask them to take it down. If it's on a website, you can ask them to take it down. You can send them a letter to persist, basically. You can supply them. Yeah, no, you can do it. You can do something about it. Absolutely yes. Yeah, absolutely yes. The question is there a problem with tampering with watermarks? Absolutely yes. There is software that can remove watermarks from images. If people do that, that's theft. It's basically outright theft. And again, don't try and sue them for breach of copyright. It's too expensive. Send them an invoice. Yes. Okay. No. Yeah. The question is, what is the situation with historical photographs that are in collections and archives in museums, etc., etc.? If it's 50 years past from the time that they were first published, or if it's 50 years from the time the images are created, they're open for fair public use. So, for instance, a good example is Ansel Adams. There's photographs of Ansel Adams that were taken that you can now use. You can print them, you can use them, you can do whatever you want to with them because they're now in the public domain. The difference is that in America, the lifespan is 70 years, in South Africa, it's 50 years. Yeah. 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 They actually can't. They actually can't. Yeah. Yeah. I mean, if you buy a photograph from them, obviously they can sell you the photograph because they're selling you a tangible object. You know, they're selling you a print. So then yes, they can sell it to you. But if you find that photograph somewhere else and you want to use it, they can't stop you from using it. Yeah. But that's only after the copyright period has expired. World War stuff, yeah. It's open to fair use. Yeah. Yeah, are there any other questions? Yeah. Sorry, start here, yeah.
If somebody comes into my lab,
Yeah.
they put the one which is scanned image,
Yeah.
or usage, say, at home, it's in the bedroom, that's what they want. What's the situation?
Okay, that's a very good question. The question is if somebody comes into the lab and asks you to scan a picture from a book that they claim they want to use in their son's bedroom or whatever it is, that's a very difficult one because a lot of printing companies are in this situation. To cover yourself, I would ask them to give you a letter stating what they intend using it for, because if you make the copy, you will be deemed to be the person breaching the copyright. Yeah. Fair use basically extends to education. So as a lecturer, I can make copies of certain things. I can show photographs, things like that. Personal use is allowed. So if they want to use it as a poster in their son's bedroom, that's allowed. The only time that it really becomes an issue is when there's money involved. So I can't take somebody's picture from their book, scan it, and then try and sell it to somebody else. That will be a definite breach of copyright. Okay. Always err on the side of caution. So if you do want to use a photograph from a book, the copyright owner will be in the book. It will be recorded in the book. Write to them, get the consent. A lot of people will consent to use of the images without payment, and that's fine. Just get it in writing from them. And if somebody says they're going to use it, like I say, just rather get it in writing from them just to be safe. Yes. All images produced are copyrighted. Yeah.
Whatever picture you take,
Yeah. 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 They do. Yeah. Every image that was produced in pursuance of the brief, they own. A very good example of this. This is where it gets a little bit of a grey area. Let's say you are a photojournalist, and let's say you sent to Zimbabwe to do a story on bread distribution in Zimbabwe. And while you're there, you go and you shoot some pictures of game, of wildlife. Okay? Whoever sent you there, whoever commissioned to send you there, even though they're paying all of your expenses to get there, okay, even though they're paying all of your costs and everything, they only own the copyright to the images that you're commissioned to produce. So if the story was about bread distribution in Zimbabwe, they own all the images around bread distribution in Zimbabwe, but they don't own the images that you've shot outside. So let's say your working day is 8 hours, and in the 9th hour you go out and you shoot a picture of an elephant. They don't own the copyright to that. Okay. However, if it's during your working hours for them, they could argue that they own that. So you have to be a bit careful of that. Okay.
You're saying that the copyrights areas lost different countries.
Yes, they do.
The US is 70, South Africa.
Yeah.
Images shot, say, in the US
Yeah.
that I shot.
Yeah.
How long is the copyright valid for? Is it 70 years because it was shot in the US, or 50 years because it was shot by a South African in the US who lives in South Africa?
Okay, there's two aspects to this question. The question is that if you are in another country and you shoot the images in another country, then are you protected by that law or by the law of the country that you're going to? There's two aspects to this. The default answer to that is that you'll be protected by default of the country that you create the images in. So as an example, a filmmaker comes to South Africa to shoot a film in South Africa, but they're actually from America, okay? The South African law will protect their copyright in South Africa. And so the same applies to you. If you shoot images in America, the American law will protect your copyright in America. So basically, whichever country the images are used in, that law will govern the use of the images, but the default is the country in which you created the images. Okay. Any other questions? Yes.
Think of something stupid to ask. It's completely thrown.
Maybe about the photograph of Cape Town.
Yes, it does, by default.
Yeah.
But you can agree otherwise. I want to, sorry, I'll come to you now. I want to give an example of this question here. If you're employed if you're a photographer and you're employed by an employer, do they own your work, own the copyright to your work? Yes, they do. Whatever you produce during working hours, they own. Whatever you shoot outside of working hours, they don't own. Now, the best example I can give you of this is the case of Sam and Zimmer. You know the photograph of Hector Peterson?
Good.
Taken during the 1976 Soweto school riots. Sam Zimmer was the photographer who captured that image. He didn't own the copyright to that image. I think it was the World newspaper, I think he was working for them at the time. They owned the copyright to it. And they made literally millions off selling the license for use of that picture. It's quite a nice story. I know we're going over time now, but I'll just tell you the story quickly because it's quite nice. President Bill Clinton in the States saw an exhibition with that photograph in exhibition. And he was coming to South Africa on a visit, and he wanted to meet the photographer of the image. And when he arrived in South Africa, nobody knew who the photographer was. Because what had happened is in the 80s, Sam Zimmer went into hiding because he was wanted by the security police. And he actually stopped shooting. And they eventually managed to track it down. Bill Clinton appealed to President Mandela, who was president at the time, and President Mandela intervened and they managed to track down who the photographer was, and Bill Clinton met him. And Bill Clinton was horrified to find that he owned a bottle store at Bushbuck Ridge, and he was living a very, very modest level of lifestyle. And the reason why Bill Clinton was so horrified is because he knew